Am I audible?
Yes, sir, you are
Can
completely
anyone?
audible.
Okay, okay.
Yes, sir,
So
completely audible.
first of all, I would like to thank Madam and Professor Sweta, Gagnija, and the whole FIMT management for inviting me for this lecture. And then I would also like to thank the participants for joining today. I have been given a very complex topic to deal with in the sense that you don't know what are you going to discuss because drafting, pleading, and conveyancing in itself is so wide that it's very tough to bind it in a territory. But still, I would like to talk about certain areas which are generally important while you approach drafting, pleading, and conveyancing. So it's a need was felt by the regulators of the legal education in the country that this should be made a compulsory module in the LLB curriculum of the country because this is a very important aspect and very important part uh, of the court proceedings. Once you pass out your law college, how you conduct yourself in courts during oral rounds is as much significant as how you draft your written pleadings, your written arguments, um, and the process that goes on before the oral arguments are finally done in the courts. So I would also state my limitation that I have been practicing in either High Court or the Supreme Court, so I don't have much of the exposure of the district courts. But still, because a draft begins at the level of the district court in most of the cases, unless it is on the original side of the High Court or the Supreme Court. So it is important to start from the scratch itself. So what do you understand by drafting? Drafting is something which is in a way you are putting something in writing. If we talk in the simplest possible terms, then drafting means that you are putting your ideas in writing. While pleading is the formal process that you file something, some written documents, your plain written statement, that is called pleading. So generally, when we talk about pleadings, we talk about civil pleadings because in criminal law the procedure is a bit different. So under the Code of Civil Procedure, 1908, we have Order 6, which talks about suit. So it says that a suit is instituted through a plaint. Order 7 deals with plaint, and Order 8 deals with written statements. So these three are basically uh, the basis from where a suit originates. So pleadings, essential pleadings are these: your plaint and the written statement. Plaint means uh, a written document which is filed before the court in a specific format as it is prescribed, by virtue of which a suit is instituted, and in response to the same, the defendant. So the person who goes to the court is called plaintiff, while the person who responds to it, who is defending the claims of the person who has filed the suit, is called the defendant. So defendant has to file a written statement before the court. These are the essential pleadings. Apart from that, there can be additional pleadings as well. There can be subsequent pleadings. There can be amendment to the plaint and the written statement. Then there can be situations where the parties may need to file some additional pleading. So we'll be dealing with that in detail when we'll be dealing with the pleadings part. Then we have conveyancing. So conveyancing necessarily means that when a property is transferred from one person to another, then we use the word conveyancing. So when we talk of movable property, the property can simply be transferred by virtue of handing of the possession. But in case of immovable property, it is necessary to register or to keep it, record it in writing that the property is being transferred. So that is done through a deed, and that deed is actually called conveyancing. So conveyancing is both the process of transferring of the property as well as the document through which the property is transferred is referred to as conveyance. So in certain cases, as I mentioned, that in immovable property it is necessary um, to have a deed. But in movable properties also we may be required to have a deed to transfer the property. That is because, say, you have a motor vehicle and you are simply handing over a possession to another person. So legally also it is required that a motor vehicle which is transferred from one person to another person shall be registered in his name, and it can be transferred through a deed only. But even otherwise, say if there is a movable property and you are transferring to someone, and there can be a danger that there can be claims that can be arising out of that transaction. And if it is not recorded in writing, then in such a case, the plaintiff or the defendant, that is the seller or the purchaser, whatever the case may be in trouble. So that's why it's prudent that we at times execute deeds of movable properties as well. So deeds may be of various kinds. We shall be dealing with them in detail when we'll be proceeding with the part of conveyancing. So as I said, I'll start with the drafting part. Uh, uh, till then, if you have any question from this introductory portion, you may proceed, because since it is a practical aspect, practical paper, so delivering a longest lecture would be very dry. So we can have questions in the meantime as well, if you are willing. Is there any question? If no, then I will proceed with the drafting part. So
If,
when we hello.
no, sir, you can
Uh,
continue. I was asking
okay.
कि अगर किसी का question है तो they can unmute themselves and ask.
Sure, ma'am. Okay, I'll be proceeding. So drafting, as I said, means putting one's idea into writing. But drafting or writing any normal document is different from legal drafting. So legal drafting can be of two types. One with study as a different subject, legislative drafting, which is uh, the formal process of making laws. So in that, the organizations or the institutions responsible for making laws involved in the process of legislative drafting. While legal drafting, when we refer to legal drafting, then we talk essentially about the drafting that is involved in the court proceedings. So the legal drafting is a specialized art. Therefore, it requires special training, special skills, which an individual may attain through learning as well as through experience. So it is, as I said, it is a practical thing which one learns while growing. So it is a process, perpetual, which continues, and no one can say that he's perfect in drafting, because there can be something or the other that you need to inculcate even at a very advanced stage as well. But there are certain things which are basic to legal drafting. So you should be clear with the law, you should be clear with the language, you should be clear with the facts of your case, and then only you can proceed with drafting in the case that you have um, with you. So when we will talk about legal drafting, so when you start with drafting, you should keep in mind certain things, that whenever you are drafting a document, or for that matter, a plaint or any pleading, it should be in the simplest possible language. It should be in active voice, and generally we tend to say that in while you arguing, it's very good to have jargons to persuade the court. But when you are drafting, the language should be kept simple, and the jargons, legal, uh, it, very complex terms should be avoided. Similarly, complex sentences should be avoided. Though this is practically impracticable for legal professionals, because as you uh, evolve through the process, you get to deal with complex things, and it's not always possible to express things in the simplest possible form. So all of us at some point of time or the other are drafting complex sentences. At the same time, we are saying that this should be done in simplest terms. But still, an attempt should be made that whenever you are drafting, it should be done in the simplest possible manner. So, for example, I would like to say that there is a lot of criticism that in India, the judges write very lengthy judgments. uh, Apart from that, the judges use languages which is not actually uh, proper for the common people. They are not conversant with the language that is used by the judges. For instance, there was a judgment in 2015 by a Supreme Court judge which had a sentence of 192 words. So such things should be avoided at the level of while you're drafting your case. I'm not talking about the judgment of the judge, but when you are as a lawyer are doing that, that should be avoided, and the draft should be kept simple. That would help you in making your arguments, in making your case better. Because whenever an ambiguity would crept in your in draft, when you will try to make it complex, it will become ambiguous, And whenever ambiguity will come, it will be detrimental for your case only, because all the claims, all the counterclaims, all the pleadings have to be expressed and have to be very, very, very clear. So if it is not clear, then the court at times may not grant you the relief merely because your pleadings were not clear. So this is established fact that the pleadings should be uh, exhaustive. So pleadings, because the courts cannot grant you a relief which is not in your pleadings. So say there might be a situation which might be a relief which may be possible in your case, but you fail to record that in your pleadings, or you don't pray for that relief. Then how can the court, particularly court which is bound by its jurisdiction, I'm not talking about the superior courts which have certain special powers, such as certain absolute powers. The district courts cannot go beyond the pleadings to grant you the relief. That's why your pleadings need to be very simple. Now, before proceeding on the pleadings part, I would like to talk about the kinds of laws that we have. So we have two kinds of laws generally. One is substantive law and other is the procedural law. So the procedural laws are those laws which lay down the procedure of uh, getting any remedy. And substantive laws are those laws which actually decides the rights, liabilities, and the duties of the party. So say we have Indian Penal Code, which is a substantive law, but at the same time we have Code of Criminal Procedure, or the Evidence Act, or the Code of Civil Procedure, which is a procedural law. So generally, uh, it is the rights of the people can only be exercised through the procedural law. Say, imagine a situation when you have laws providing for your rights, remedies, liabilities, and duties. You have the Sales of the Goods Act, but imagine the situation that you don't have the Code of Civil Procedure. How would you be approaching the court? So therefore, procedural laws are equally important and relevant. Though it is said that the procedure should be the handmaid of justice, therefore procedural law should not come into the way of justice, but approaching the same thing through another perspective, we can say that procedure should be actually facilitating the justice. So therefore, when we talk that the procedure should be facilitating the justice, uh, we should understand that the procedural law has to be clear, has to be because ambiguity in procedural law will lead to confusions, and therefore it will be leading to detriments to the common litigant. As I told in the beginning itself, that because the quality of legal drafting in the country was felt that it is not up to the mark, that's why it was thought of introducing a special curriculum at the LLB level. So we should understand similarly that whenever there will be confusion either in the laws or in the pleadings or anything, that would be costing to the ordinary litigant. That's why the importance of the procedural law has to be emphasized. From there comes the aspect of pleadings. Say there would be a right which you have, a claim that you have against a particular person. The other person is having a liability. When you have a statute giving you that right and conferring that liability upon the other person, say Indian Penal Code, but you don't have the procedure, how will you be getting the justice? But at the same time, you have the procedural law, but if the procedure is not clear, then how would things work? So that's why the procedures lay down an uniformity, which is an essential characteristic of law. So when there will be a uniform pattern, uniform criteria, uniform laws, uniform rules, then we can think that the parties will be having a certain level of certainty in their minds that yes, law works in this particular way, and we need not to worry about how this has to be done. In most of our courts, till the Supreme Court level, we have format-based drafting. So whatever pleadings that you are having has to be in a particular format. So all these are necessary because to ensure the smooth functioning of the system. So when we move to the pleadings part, as I told you that in civil pleadings, it's the plaintiff which institutes the suit. Then there comes the written statement of the other party. Then there can be additional pleadings in the form of answers, replies, rejoinders, or any declaration or any memorandum, or for that matter, even parties file written arguments in the court, particularly at the High Court and the Supreme Court level. Written arguments are filed in which relevant precedents are mentioned, and on the basis of that, a decision is to be sought in a particular case. So I hope there is no confusion till this point. If yes, you may ask, or I'll be proceeding further. So if you are having a copy of the Code of Civil Procedure with you, I would like to briefly go through Order 6, 7, and 8. Then I'll be proceeding. Should I share my screen over here?
You can share your screen, sir, if you want to.
Oh, okay, okay.
Are you able to share, sir?
Yes, ma'am.
Yeah. Okay, yeah.
So I am sharing the draft of CPC with you. Order 6 is headed as pleadings generally. Then the first rule under Order 6 is pleadings shall mean plaint or written statement. So as I told you that these are the pleadings which are filed in a suit as a matter of right. So parties will be filing plaint and then the written statement. Obviously, when I say as a matter of right, then it is subject to the provisions of the Code of Civil Procedure, whether the court has jurisdiction, whether the parties are competent, whether they are necessary parties. Subject to all that, these are essential pleadings in a suit. Then you have to understand certain basic principles of uh, uh, pleadings. So when we say pleadings, when we should understand that uh, the pleadings are the contentions of a party put in writing. So when we say plaint, it is a contention of the plaintiff, which is sorry, it is the claims and the issues in controversy from the side of the petitioner, the plaintiff, which is put in writing. Similarly, the written statement consists of defenses and denials of that particular person who is the defendant in that particular case, or maybe a set of persons, or the parties who are representing the defendants in that particular case. So uh, why pleadings are necessary? We should understand that pleadings are essential in order to determine the nature and the extent of the dispute. If you will not be laying down a pleading, say a suit will be relating to a particular subject matter, but if the pleadings are not in place, then how can you determine that to what aspects of that particular subject matter a suit is being filed? Therefore, complete pleadings have to be filed, laying down the claims that the plaintiff is having in that case. Apart from that, that at the same time it serves the purpose that a fair notice is given to the other party of the case. Then the parties, uh, as well as the court, have an advantage that they know exactly as to what issues are in picture in that particular case. And again, as I said, that the relief in that particular case would be limited to those pleadings only and cannot travel at any time beyond the pleadings. So then I would again like to return to the Code of Civil Procedure. There is a basic principle that pleadings are not to state the laws. Pleading should be stating facts only, and all the facts, all the material facts. In a pleading, no material facts should be omitted, because if you will be omitting a material fact, then that would be detrimental to your case only, not to anyone else. In fact, the other party would be benefited by any omission on the part of the person who is instituting the suit. Similarly, in the case of a written statement, it will be advantageous to the plaintiff. So similarly, when you are instituting your pleadings, you should not be giving evidence. Say, when a suit is filed, documents are to be placed in order to bring on record all the relevant evidence or the backing from which a particular claim is being made. But the pleading part should not be containing the evidence or the law. So pleading should be limited to the facts only, to the material facts only. Are you able to see the PPT that I am sharing?
Yes, sir, we are able to see it.
Yes. So pleadings, I have attempted to make a PPT of it. Pleadings should be stating only facts, not the law. So facta probanda, as we call it, should be stated, and facta probancia should not be stated. So evidences should not be stated. Then the pleading should be precise, certain, and concise. Then the conclusion should not be reached at. So when I say that laws should not be stated, or um, evidences should not be stated, or conclusions should not be reached at, by that I mean, let's say you have gifted something to someone. You cannot simply say that a gift was made to this person by this person. You have to state that there was an object which was in place, which you gifted to a particular person on a particular date at a particular time for a particular region, that the possession was given to him. So it should be elaborate. It's the work of the court to reach the conclusion. Similarly, you cannot say, if there is a document, you can rely on the same, obviously, but you cannot say that this is in place, therefore say if a sale deed is placed in place, you cannot say, if it is in issue, that whether the sale took place or not, you cannot simply say that the sale took place. Instead, you can say, elaborate the transaction, and it's upon the court to determine whether the sale actually took place or not. So similarly, you cannot say in case you are owing some money to a particular person, and the particular person has instituted a suit against you, you cannot conclude directly that you don't owe anything to that particular person. You can although state that you haven't borrowed any money, there was no monetary transaction between you, between the two persons, therefore you are not owing anything to that particular person. So what I am trying to emphasize is that you should not be putting in law. Similarly, uh, apart from certain aspects like limitation, there are certain exceptions to the fact that law should not be pleaded. Uh, Apart from that, those exceptions, plain law should not be put in the pleadings. That is the requirement. So uh, you have to proceed accordingly. The CPC also accordingly defines it, that if we read rule 2, pleading to state material facts and not evidence, every pleading shall contain and contain only a statement in concise form of the material facts on which the party pleading relieves for his claim or defense, as the case may be, but not the evidence by which they are to be proved. So evidence has to be attached with it, but the evidence should not be in the main pleadings. Then every pleading shall, when necessary, be divided into paragraphs numbered consecutively. So this is for the purpose of simplification, numbered consecutively. So you should be numbering all the pleadings one after the other, and one fact should come in uh, in one para if possible. So each allegation being, so far as convenient, contained in a separate paragraph. Then dates, sum of numbers shall be expressed in a pleading in figures as well as in words. So there are certain other rules which govern drafting, that numbers above 100 should can be written in numbers only. But it's always better if you write the numbers, the dates, and the sums both in figure as well as in words. Then we'll move to the other parts. There are certain exceptions that have been laid down in this uh, order itself. I'll be explaining them in brief uh, through the PPT only. I'll not go into the text of the law because that may be complicating, and I understand that there may be students from first years from the who have not yet studied CPC. Then we have Order 7, which contains plaint. So the rule 1 to in Order 7 describes what particulars a plaint should contain always. So a plaint shall contain the following particulars: the name of the court in which the suit is brought. So generally we write in all caps the name of the court in which the suit is to be brought at the top of the whatever pleading that you are making. In this case, the plaint. Then the name of the description, name, description, and the place of the residence of the plaintiff. Similarly, the details of the defendant. Then whether plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. Then the facts constituting the cause of action and when it arose. The facts showing that the court has the jurisdiction. So you will have to state the relevant law under which the court is having jurisdiction. So in this case, you will be obviously citing the law uh, to show that the court is having jurisdiction on the basis of the pecuniary limit or the territorial limit or due to the residence of the parties. Then the relief which the plaintiffs claim. So generally we draft it in the form of the facts, the grounds. Then our prayers are stated. So, but all these material things should be contained in that particular plaint. If it is missing, then the plaint will be incomplete. Then, where the plaintiff has allowed a setup or relinquished a portion of his claim, the amount so allowed or relinquished. So all the things should be on the record. Then there are certain things which you need to keep in mind. We have Rule 7 to this order 7, which says that the reliefs has to be specifically stated. So every plaint shall state specifically the relief which the plaintiff claims, either simply or in the alternative, and it shall not be necessary to ask the general or other relief which may always be given as the court may think just. Before I proceed further, there is an expression here, either simply or in alternatives. So what happens that there may be two arguments that you might be willing to take. So in grounds as well as in prayers, you can make alternative arguments, although there are limitations to that. They cannot be contrary to law. They cannot be in juxtaposition. So if you are making an alternative argument, so simply you may have more than one argument on merits on a particular set of facts. Then in that case, your ground should be stated in alternative, but clearly. They should not be intermingled. They should be stated clearly. So therefore, the court may grant relief which have been specifically stated in the plaint that has been instituted. Similarly, the reliefs that you are claiming, the distinct claims or cause of action which you are claiming shall be based on the different grounds. So they may be arising of the same sets of facts, but they shall be on different grounds. Then there are certain things about admitting the plaint and returning the plaint. Then we'll move to the next part, which is Order 8. So it talks about the written statement. The defendant shall, within the 30 days from the date of service of summons on him, present a written statement in his defense, provided that where defendant fails to file a written statement within the said period of 30 days, this is about the limitation, but the defendant has to essentially file a written statement wherein he will be reverting to the arguments to the contents of the plaint, and see again the rebuttals or the denials that the person would be giving have to be specific. So whenever you will be interning or you will be going to courts, whenever your senior or you yourself would be drafting something in written statement or in the higher courts in the form of counter affidavits, you have to answer everything that has been given in the plaint, or for that matter in the writ petition or the special leave petition or the appeal memo. You have to reply to everything, and wherever you are to deny that particular thing, you have to specifically deny it. Otherwise, it will be amounting to admission if you are not denying something specifically. So therefore, the rules too says that if there is new fact, then they have to specifically plead it. Similarly, if there is a denial to any particular fact that has been raised in the plaint of the other person, then the denial has to be specific. Rule 4 talks about evasive denial. Where a defendant denies an allegation of fact in the plaint, he must not do so evasively, but answer the points of substance. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. So therefore, you have to specifically answer to a claim that has been there. You cannot simply say something and omit responding to certain other aspects of the same facts. that would, in certain case, may amount to admission as, I mean, in absence of specific denial, would be amounting to admission. Then I'll again proceed with the PPT. I hope there is no question till now. Is there any? Are you able to follow me?
Sir, can you hear me?
Yeah, yeah.
Good evening, sir. My name is Kunal
Good
Kapoor.
evening. Yes, good
Sir,
evening.
I have one question.
Yes,
As we studied in Order 8,
yes,
that the person have to reply in 30 days
yes.
for the summon. Is it only for someone or also for a legal notice which is only sent by an advocate, not by a court? It is not an summon, it is just a legal notice. So for
See,
this, that.
there
Hmm,
is no particular law governing a legal notice. So generally,
hmm.
lawyers write at times you have to reply to it within a month. At times you have to reply to it within 2 weeks. So there is no strict condition for a legal notice. Though, if within a reasonable time after giving the legal notice to that particular person, the person is not replying, then you may obviously have to approach the court, and that is the purpose of legal notice. Either the dispute is resolved outside the court, or you have to approach the court.
On the basis of like a legal notice, अगर मैंने किसी को legal notice भेजा and he is not replying for like a month or for a like any a particular time period, so
Yes.
क्या वो एक ex parte माना जाता है
No,
as
no,
per
you
any
have
law?
to you have to
Hmm.
go before the court before anything can be said ex parte. Legal
Okay.
notice is extra, I mean, outside the court process, so you can have an effect of decree or anything claim based on a legal notice. That is only indicative of the fact that you were aware of your rights, you tried to settle the dispute, or you approached to a solution to the problem, but it was not possible, and therefore you are approaching the court. In certain other cases, it is required by the statute only that prior to filing the plaint or the case before the court, you have to uh, 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 serve a legal notice upon the proposed defendant. So that may be a different scenario. But in no case you can say that it is, and the legal notice is in a way serving as an ex parte decree or something like that. Is that clear? Can I proceed? Okay. So there are certain exceptions to what I said, that the pleading should be stating facts and not laws. See, there can be certain situations where it might be very difficult to distinguish between facts and the laws, particularly in the cases of appeal. When you say that the court did not follow this particular law, you are mentioning that particular law, but it is not possible to mention law in pleading. So at least whenever you are mentioning the factual portion of that particular plaint or that legal document, you should not include law in it. But when we will proceed to see the exceptions that are possible um, to this general principle of not stating laws in the plaints or the pleadings, there are certain exceptions, that because foreign laws are not authorities in the Indian courts, therefore foreign laws can be stated in the pleadings if they are applicable to a particular case. Similarly, if there is a mixed situation, mixed question of fact and law, in those cases, laws can be pleaded in the pleadings. Similarly, if there is a condition precedent to the filing of the suit, or to the particular fact which is required by any law, in that case the law may be pleaded in the pleadings. And similarly, customs and uses of any particular community or trade. Say, if you are renting out your house, and in particular city there is a practice between the landlord and tenants which has attained the status of a custom in that particular area, that it has to be followed. So unless you don't specifically mention that uh, in your pleadings, the court would not knowing about the existence of the same. Therefore, that has to be specifically pleaded. Then we'll proceed further. When we talk about pleadings in the superior courts, so in the high courts or the Supreme Court, then the pleadings are governed by some other the rules of procedure laid down by those courts. So, as you know, those of you who would have interned in the Supreme Court, the pleadings in SLP have to be in 8 paras. If your SLP is not in 8 paras, or where an interim relief is not sought, In that case, if the SLP is not in 6 paras, then the SLP would not be cleared at the level of the registry. So it has to be strictly format based. So what do we plead in either in appeal or in writs before the higher courts is that the facts have to be stated in the form of a synopsis and the list of dates. Then you state your grounds. Then the question of laws come, because in most of the cases, uh, an appeal, or for that matter, a writ should essentially contains questions of law that are required to be, though this is not necessary to be considered by that particular court, may depend from case to case. So the questions of law should come, and then come the prayers of the parties. In case you are seeking an interim relief, then the grounds for interim relief and the prayer for interim relief should also be there. Then we proceed further. In criminal proceedings, the proceedings are governed by CRPC, and there you have different stages of a trial, right from FIR to the court taking cognizance of the charge sheet and then proceeding with the trial. There is nothing in the sort of written statement or the plain. There you have different requirements. The evidences are let down. The witnesses, the testimony of witnesses happens. Then there are cross examinations. Then there are the statements by the accused. Then you have same process from the defendant side, and then finally the arguments between the parties take place. At that stage, written arguments can also be filed by the parties. So all this is governed, but the basic principles remains the same. You have to be clear with your draft. You have to specifically plead something. You don't have to be ambiguous in your pleadings. That would be detrimental to your case only. So all these things have to be kept in mind while you are drafting a pleading in a criminal case as well. This was for me on the aspect of pleadings. Do you have any question other than this on the aspects of pleading? Because we can proceed with the discussion. We can elaborate on the discussion
Hello,
once we have the questions. Yes,
sir, I'm audible.
yes, you are audible.
Sir, I want to know that condition precedent, Order 6, Rule 6.
Okay,
Condition precedent include the Supreme Court guidelines also.
condition precedent may include the Supreme Court guidelines. If there is a specific Supreme Court guideline, so by virtue of stare decisis, and because by virtue of that the laws let the judgments of the Supreme Court are the law of the land, therefore condition precedent can be uh, uh, a Supreme Court directive as well. If we read this, any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleadings by the plaintiff or defendant, as the case may be, and subject thereto an avowment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleading. So yes, the judgments of the Supreme Court are binding. Similarly, uh, if there are apart from CPC, the state governments are empowered to make amendments in the CPC in their particular states. Then the high courts are empowered to make rules under the CPC. So if there is a condition precedent laid down under the rules as well, then also you have to follow that. And for that matter, if the condition which is precedent to any particular act, which is not coming from the may come from any other statute as well, or for that matter, if you are challenging, it completely depends upon the facts of a particular case, what laws are applicable to them, what orders are applicable to them. So when you study in constitution, you study under article 13, the laws and law enforced. For certain purposes, only laws made by the legislature are considered to be laws. For certain other purposes, laws made by the delegated authority or by subordinate authority or laid down by the courts are also considered to be the laws. So it will depend upon obviously the facts of that particular case also. Is that clear?
Yes.
Anyone else?
Any questions anyone wants to ask?
So I shall be proceeding with the conveyancing part um, um, hereafter. But before that, we can again emphasize on the fact that a lawyer has to be very specific while he lays down his facts, unambiguous, very clear, and very bold while laying down his fact. The format that is given for a plaint has to be followed, or for that matter, the procedures under which that particular case is being governed in that particular case have to be strictly followed. You have to keep these aspects in mind, and then you should generally prefer to follow an uniform format, and you should adhere by the basic laws of drafting. Then we shall be moving on the conveyancing part. So when I say conveyancing, conveyancing is an act. Is the screen visible to you?
No, sir, not to me. I think you need to share again. Yeah.
Yeah.
Yes, sir.
So simply stating, conveyancing is an act by which a property is conveyanced or voluntarily transferred from one person to another person by means of a written statement or other formalities. So when you say conveyancing, it's a process of transferring property from one person to another person. So it can be both uh, the movable property as well as the immovable property. As I told you, conveyance is used for the document as well as the process of transfer of that particular property. Then what is conveyance? Till now we were talking about pleadings. Drafting is overall. Drafting, whatever you do in a specified format in a uniform ways can be termed to be drafting. But what is the difference between a conveyance and a pleading? Pleading is generally something which you are filing in the court, which is presented to the court for effective adjudication of that particular case. Conveyancing is nothing of that sort. Conveyancing is an evidence that is created that a particular property has been transacted between two particular persons. So, it for the purposes of proceedings in the court, a conveyance only serves as a transaction. So, a conveyance can be in the forms of various deeds. What is deed? So, if we go to the literal meaning of deed, it is an act of a particular person. So, this is similar to the act of transferring the property, which is being recorded on a paper in the written form, so that the rights, the liabilities arising out of it, the different conditions of the deed can be let down, and there is no ambiguity. So, if we refer to Section 2, Clause 10 of the Indian Stamps Act 1899, it has defined the term conveyance as conveyance includes. So it is an inclusive definition. Conveyance includes a conveyance on sale and every instrument by which property, whether movable or immovable, is transferred, and inter vivos, and which is not otherwise specifically provided by in Schedule 1. So if we leave the latter part of the definition, which talks about certain kinds of documents which have been laid down in Schedule 1 of that particular act, conveyance is a document which is through which a property is transferred or is on sale uh, from one person to another person. Then we move to the next slide, which talks about what a conveyance document should contain. So at the top of it, it should be containing the description of the deed. Then thereafter, the date of the deed shall be provided. Then the parties, and what the parties shall be called with, the reciters of the parties shall be provided. Then it shall be written that this agreement is being executed between so and so parties. So you can whenever you execute an agreement, you write that this agreement is being executed between Mr. X or Mrs. X, hereinafter called as the first part or the party on the party on the first part or the first party, and between so and so, hereinafter referred to as the party on the second part or the second party. So that is the recitals. Then you mention the consideration, if there is any, in that particular case. So if a transaction is taking place, there must be certain consideration on the basis of which that transaction is taking place. So that has to be recorded on that document. Then whether that amount has been realized or not, or whether that will be paid afterwards. When has the delivery of the good or the property has to take place? Then thereafter you elaborate the details uh, about the property, the manner in which the transaction is to be executed, and if there are any exceptions or reservation. So say if you are making a conditional sale of any particular thing, then that also has to come in record. Obviously, if there is a conditional sale, that has to be subject to the laws, and no agreement between two parties can be illegal. Then then there is habendum part. So habendum is generally referred to as uh, it is in the form of, just a moment. Yes, this is the here it has been defined that this is familiar to have and hold. So you say that the particular party shall be holding this property hereinafter, uh, which shall specify that the property is being transferred. And generally in sale transaction, we also refer to about the liabilities of a particular transaction. So we say that from this time to this time, this party shall be having the liability of that particular thing or property. And after the sale takes place, a time may be specified that after that particular time, the other party shall be responsible. Then finally, the testimonium part. So testimony comes, and the witnesses. We have already stated that in the witness of so and so it is being executed, and finally you write that um, these are the witnesses, and the witnesses sign there and the parties also sign there. Then I would like to also say you that in pleadings as well, the pleadings have to be signed either by the parties. It is a requirement of CPC and even otherwise in the rules of the courts that the pleadings have to be signed by the parties. When you will be studying drafting part, you will be told that whenever you draft a document, a verification should be following it. So whenever you draft a petition or a plaint or a written statement, a verification of the party either in the form of an affidavit or in the tail of that particular document only should be followed, that yes, that document has been read to him in his vernaculars and that he has understood the contents of the same, and that the document has been prepared on the behalf of that particular party, because ultimately it's the instruction of the person whose stakes are involved on which you are acting, and therefore you cannot go beyond what is the desire of the party or what is the requirement of the party. Obviously you can give your legal opinion, you can tell them about the applicable laws, but it's ultimately the party who is exercising their rights through the council. That has to be understood. Then I would like to show you some of the drafts. You'd already be seeing it when you'll be in the subsequent models, when you will be um, given lectures on the different kinds of pleadings or drafting that happen in courts. But I would like to show you some of the drafts. So I'll start with the conveyance. The document that I am referring to is the case material of the Delhi University, which is provided to the students for the purposes of their understanding of the topic. So you can see this. This is the title description of the document. This is a will. Then here comes that this is the last will of and testament of Mr. So and so. The parties would be stated here and after, because here the one would be the testator and one would be the person in whose favor the will would be executed. So all the persons associated with this particular person would be described herein only, and then you will describe all the property, and then you will be describing how the property has to dissolve and in whose witness it is being dissolved, and when it shall come into picture. The wills can be in the form of registered as well as unregistered wills as well. Similarly, this is a power of attorney. There can be a sale deed. power of attorneys are two forms. Um, Power of attorney can be specific as well as a general power of attorney. Similarly, this is an agreement to sell. So you at the top of it, you are writing agreement to sell, which means you are giving the details of the document. Then you are writing the date of the document, that this document is being made on so and so date. So you generally write it that is made at New Delhi on this particular, so on this 21st or on this 15th day of February 2024. Then you write that between Mr. So and so and who shall be the vendor. So because it is a sell, so who shall be seller or a vendor, whatever expression you may like to use. Hereinafter referred to as the vendor, which expression shall, unless repugnant to the context or meaning thereof, shall mean and include his highest executors, administrators, and assignees of the first part. Similarly, you describe about the second party, then you describe about the rights of the owner regarding the property, and then you write that hereinafter it has been agreed between the parties. So from here only the agreement starts. It is not that the actual agreement is the whole document. When you write that it is hereinafter agreed between the parties, the part which follows this expression is only the agreement between the parties, and on the basis of the same, the rights and the liabilities of both the parties are defined. The consideration is defined. Then the property is described, and finally, you put in that in the witness of so and so, this agreement has been signed between these parties, and then the parties sign, and then the witnesses sign, and this can be either registered and unregistered. Similarly, if I would like to show you some drafts of pleadings, most of you who would have interned in courts would have seen this. But say, if I show you a pleading, and yes, every suit has to be accompanied by an affidavit. So whenever you will be filing a suit or a written statement, the affidavit of the party would also be going along with this. So this is a suit for permanent injunction. At the top of it, it is written suit for permanent injunction. However, in the actual court practice, as I told you, in the first line, the forum before which the case is being filed will come. So you'll write in the court of senior civil judge, or in the court of the honorable district judge, or in the court of, or in the honorable high court, or in the honorable Supreme Court of India. Then you will be writing the details of the case. Then you will be writing about the parties. So in the matter of so and so versus so and so, the cause title comes first. So here, the full residential address is also coming because of the requirement of the Code of Civil Procedure. Otherwise, in the higher courts, you just write the parties, and thereafter you have to file a memo of parties in which all the details of the parties come. So then you write for suit for permanent injunction. Then you, after writing most respectfully submitted or so it, you detail the everything, and then you proceed for prayers. Every detail has to be given, all the material facts, the jurisdiction of the court, and everything has to be provided therein. And then you will be proceeding with your prayer. Your prayers also have to be specific. As I told you that if you will not be mentioning that particular prayer in the suit, it will be very difficult for the court concerned to grant you the remedy. Then the party signs it, and again this is supported by an affidavit. So this affidavit is coming in the form of the verification that is following it. So in certain documents, it is in the form of the verification in the tail of the document, while in the other cases, it can be in the form of a separate affidavit. Generally, it goes as a separate affidavit. So this is what some of the basic aspects of drafting, pleading, and conveyancing that you should always have in mind. About specifics relating to specific topics, you'll be taught by the other resource persons who would be coming. In the conclusion, I would like to say that whatever you study about drafting, pleading, or conveyancing, obviously, in classrooms would not be adequate, because it's ultimately a thing of practice. Unless you draft one or two plaints or write a written statement or appeals or counter affidavits, you would not get to know the nuances and nitty-gritties of that particular draft. So that's why we say that the only practice would be leading you to perfection. You have to understand that when we say that everything should come in the plaint, you have to go into every detail of the thing. So when you will be dealing with a criminal case, you cannot say that if you are to prepare a counter affidavit in a criminal case, you can only go through the judgment of the subordinate court, and some other documents say the memo of appeal being presented by the other party, and on the basis of that only you can prepare your reply or counter affidavit. That would be very detrimental to your case, because see, the same fact may be expressed in different forms. Lawyers, it is said about the lawyers that you get your first, you get your facts first, and then you can twist them. So the
Sorry
lawyers
to
generally,
interrupt you, sir.
yes, ma'am.
Actually, your screen of pleading is not visible. The PPT is visible, but as
Yes,
you
ma'am.
are saying, you are sharing a draft of a pleading, so that is not visible to the students.
The draft, it was not visible at all.
No, no, sir, it was not.
Okay.
We can try to share the screen again. तो वहाँ पे एक window का option would be given.
Yes.
So thereby you can select the pleading. Yes.
Are you able to see it now? Is it visible now, ma'am?
Yes, sir. Yes,
Yes,
sir.
sir.
It is visible.
Completely visible.
So see, this is a draft of suit. So you don't write suit for specific performance there. You simply write in the court of so and so, suit number so and so year, and in the matter of so and so parties, which you will write the details of the parties. I was saying that in the higher courts generally you just refer to the cause title, and the details of the parties are filed separately as a memo of the parties. But when you institute a suit, all the details of the parties, like his father's name or husband's name or wife's name or whatever, and the residence of that particular person has to be specified therein only, for the plaintiff as well as the defendant. If there are more than one defendant, then you will write defendant 1, defendant 2, defendant 3. You should generally see, this is a rule of drafting, that when you then I'll tell that about that later on. Then we write about the content of the suit, what is the suit is about. So suit for specific performance of contract. You'll write this, and then you'll proceed after stating most respectfully so it that the plaintiff is so and so. So trivial facts may be stated in the first two paras, so that the court has an idea about what the case is about. So you'll be saying that the petitioner is a resident of so and so, is in so and so profession, it has so and so background, and this case is relating to such and such things. Then you will be simply also detailing about the defendants as well. Then you will be proceeding to state all the material facts that are required in order to adjudication of that particular case. And then you will also be writing about your grounds in that particular draft. Although in suits, generally the facts are to be mentioned, the ground can be inferred during the time of the argument. So if you refer to this plaint, if this to this plaint, it is saying that the plaintiff is resident of so and so, that the defendant is the absolute owner of the property bearing so and so number, and the measure of the property is so and so. Then that the plaintiff was in the need of property for residential purpose and came to know that the defendant is interested in selling the suit property. So this is a claim for specific performance. So there must have been a contract between the parties, of which one of the parties would have resigned it from performing the contract. Therefore, a specific performance suit would have been filed. Just a moment. Hello. Am I audible? Hello.
Yes, sir, you are audible, completely audible.
Okay. Thank you. So then you will be detailing everything, the exact timeline, the facts, everything of the case, and then what is the basis of your claim. So you'll be saying that yes, there was a sale transaction between the two parties, due to which you had to pay certain amount to him. Apart from that, you cancel plans to purchase other properties, and then you came to know that the other party is not willing to sell you the property, or is willing to sell the property to someone else, or is not willing to sell the property at all. So because you are at a detriment, so you can claim a specific performance of that contract. Therefore, you are filing this suit. So you will detail all these circumstances in the herein only. Then you will say that this suit is within the period of limitation because it has to be stated whether it is in the period of limitation or not. If it is not within the period of limitation, you have to say why the court should waive off the limitation period and what are the grounds for such waiver of limitation period. Then you have to state that this honorable court has jurisdiction to entertain this suit because the cause of action arose within the territorial jurisdiction of this court. And you can also say the other things relating to the competence of the court. And that the requisite court fees have been paid, and then you will be stating your prayers, and then the plaintiff would be signing, his advocate would be signing, then the same would be verified. In certain other, I was saying that in certain other planes, you might have an attached affidavit which would accompany the plaint that is being filed. Similarly, there is a format for written statements or written statements filed on the behalf of the defendant in the particular case. So you'll write in the court of so and so, district so and so, suit number so and so, between X and Y, and then you will again at the top you will write written statement on behalf of whatever defendant that the person is. Then you will write everything in detail about the case. So generally we start with preliminary objection. This is so because in a case where the facts have been stated by the plaintiff, as I said that the facts can be twisted. So the same facts can be presented in a different way, or there can be concealment of some material facts on the part of one party. Therefore, you have to state your facts differently. So you will be you mentioning your preliminary facts or preliminary objections in the beginning itself. Then similarly, when we do it in higher courts, when we do it in counter affidavit, we name it either preliminary objections or preliminary submissions or something similarly worded. Then you will be replying on merit. When you will be replying on merit, you'll be rebutting to every ground that has been stated in the plaint of the other party. So, see, the expression here is that without prejudice to the preliminary objections stated above, the reply on merits, which is without prejudice to one another, is as under. So, you will be replying on merits. You will be specifically denying everything. If something is correct, say if we see para 1 here, is it clear to you all? Then it says that the contents of para 1 of the plaint are correct and is admitted. This is so because generally the contents of para 1 in every case are either the details of the parties or certain events which in which there is no tweaking. It is just the clear statement of the event. So the other party may admit that. But the subsequent paras are contents relating to contested facts. So you don't have to admit that. Obviously, you will be denying that. So the denial has to be specific. So see, it is saying that the contents of para 3 of the plaint are absolutely incorrect and are denied. So this is a specific denial. Apart from that, you have to also counter them. So you will be presenting your fact. So it is specifically denied that the plaintiff is the owner of the suit property. As a matter of fact, Mr. N is the owner of the property. So when you are clearly rebutting it, I say that I am the owner, and you say that no, you are. I am not the owner. Some third person is the owner. So it is a clear rebuttal. So as far as possible, the rebuttal should be clear. If there is ambiguity in the rebuttal, the court may be bound to draw an inference, obviously on the basis of the evidences. So these are the certain things that have to be kept in mind. And at the tail of it, you will be writing the prayers. So obviously your prayers should be contrary to what has been prayed by the other party. The prayers have to be specific, very clear. You drafting prayers also is an art which you will be learning with times. At times, what happens that in moot courts as well as in other proceedings, we tend to take the aspect of prayers lightly. But prayers are the most important facts, important things, because whenever you will be going to the court, the first thing that the court would be seeing is what are the prayers in this particular case. Then they will decide whether it is a competent court to grant those prayers, whether the court has jurisdiction or not. So prayer are the initial point of a case at many occasions. So therefore your prayer should be clear, and you should keep in mind everything while drafting prayer. So say if a court is having a pecuniary jurisdiction of 2 lakh rupees and you are making a claim of 3 lakh rupees in the prayers. So at that instance only you are barring the jurisdiction of that particular court, and your suit would not be admissible. So therefore, you have to be very specific and very clear with the laws, as well as the facts at the time of drafting the prayers. And then after the prayer, the sign of the plaintiff and the advocate would come, or it would be accompanied by an affidavit, as the case may be, as per the requirement of that particular court and the particular case. So similarly, I tried to show you a draft of a conveyance which has to contains the specifics, as I told you. Then this is a transfer petition which will be lying in the Supreme Court of India. So a transfer petition from one state to another has to specifically lie before the Supreme Court only. Because under the scheme of the CPC, a transfer, the intra-state transfer can be done by the High Court, but when it is inter-state transfer, it has to be done by the Supreme Court only. So generally, matrimonial proceedings go before the Supreme Court in the form of transfer petitions. So in drafting a case before the Supreme Court of India, the format given by the Supreme Court of India has to be followed. So you'll be writing the details of the parties. Similarly, in the matters of so and so, and then the petition is presented to the Chief Justice of India and his companion judges. Then in the first para, you write the details of the case. This is a very short para. Then in para 2, you are expected to state the facts. Then you are to state the grounds. Generally, the pleadings before the Supreme Court start with a synopsis where you state your facts very briefly, which is governed by the Supreme Court rules, obviously, in which you will be giving a synopsis. Then a list of dates follows after that. Then other things which are required as per the format. Then after the impugned judgment, the case starts with para 1, which in the first para you have to detail the case. Then in the same, that is followed by the grounds that you are taking. That is followed by the question of law that is arising in that particular case. So in a transfer petition, a question of law may not arise. It is solely be based on the facts of the parties of the case. Then you have to write about the grounds that are there in that particular case. There are two paras in which you have to state that no other similar petition has been filed. There is another para in which you have to show that all the details of all the documents that are being filed with this particular case were before the subordinate court as well. And then you have to state the grounds for main relief and the ground for the interim relief. Similarly, the prayer for the main prayer, and then the prayer for the interim relief have to be there. And finally, you conclude, and it is followed by an affidavit. So what I wish to state is that you have to be very clear. You have to follow an uniform format, and you have always to be very clear in your expression. Otherwise, that may be problematic to say. If we say the parties, so there are certain things that you should be avoiding in certain cases. When there is a case, then you should not refer the plaintiff as Mr. So and so or Miss So and so, or he did so, she did so. You should always be writing that the plaintiff has done so, the respondent has done so. If there are multiple plaintiffs or multiple respondents, then you may write plaintiff number 1 has done so, plaintiff number 2 has done so. For purpose of clarity, you may write that plaintiff number 1, Mr. So and so, has done so, but you should never refer to a person in pronouns. Similarly, you should never refer to the parties directly by their names. These things have to be taken care of. Whenever you draft for a court proceeding, you don't simply go and to state that the Supreme Court has held so and so. You will be writing that the Honorable Supreme Court has held in this particular case at so and so. So there has to be a way of presenting the case. You cannot go on to impute motives to the court or to the party. So things have to be said in a subtle way. Whenever you will be referring to a trial court, you will be saying that the learned trial judge or the learned trial court. All these things have to be considered and have to be taken to be kept in mind while you are drafting a plaint or anything. So these things are important. Then I'll be moving to the conclusion part. I hope the PPT is visible to you. Is it so? No. I'll be sharing.
So no, PPT is not visible as of now.
Yes. So,
Yes, now it is.
as I was saying that these aspects relate to practical learning. Your practice would be leading you to perfection. You cannot say that you will be perfect from the first draft itself. You will be learning, you will be refining yourself, uh, one draft after another, and in a matter of time, in 2 3 months, in for some people in some years, and for some people in a matter of days, you will be well versed with it, and you may draft any sort of complex pleadings in some days. When we practice in the Supreme Court, there are some cases in which you have to take more than 50 grounds, but they have to be taken. All these complexities you will be learning with time. There may be cases involving complicated issues where you have to take many grounds in alternative, or there can be many questions of law involving in the same case. At times they may be contradictory, so they have to be presented in such a way that the court understands it clearly. It is important that the court understands your case clearly, otherwise you will not be getting the relief. And ultimately the object is to get the relief for your client, of for that matter, for the case. Otherwise there is no meaning. So if you will not be clear in your expression, if you will not be very uh, upfront, very uh, if you will be ambiguous in your presentation, that then that would be problematic. So that's why I was saying that details have to be taken care of. I was giving the example of a criminal case. Whenever you are dealing with a criminal case, every small detail has to be taken care of. There can be times when a trial court judgment can be set aside on the basis of a mere omission or mere extraneous consideration of a fact. So every detail has to be taken care of. You have to go through every document. It's not that you have understood the factual matrix through one document, then you can omit going through the other documents, because that would be, in a way, not giving you the complete picture of the case. And as I said, that the other party will be presenting the case as per their convenience. So though they have attached 10 documents, say they have attached the FIR, they have attached the charge sheet, they have attached the trial court judgment, they have attached if it is a case of murder, in the postmortem report, if the forensic evidence is available, the forensic report, the testimonies of different witnesses, the different documentary evidences. But at the end, if you rely by their version, you will be causing a detriment to your case. Therefore, you yourself have to go through all those documents, find the loopholes, and then you have to conclude. You have to reach to a conclusion, or reach to an if I can refer to reach to something on the basis of which you will be making up your case further. So these things have to be kept in mind. And then we should understand that we are in a very noble profession. This profession is not something which is focusing on the individual. Our growth is obviously important, but our growth should not be at the cost of the litigant or the client that we are representing. So the paramount importance should be given to the interest of the client. So therefore, your work should be keeping in mind the last person who would be affected by your actions, and that is important. So therefore, you should focus on simplification. In that way only, you will be ensuring that you are simple, you are clear, and at the same time, you are ensuring that the justice reaches the last person in the spectrum. This was all from my side. If you have any question, then you are welcome.
I have two questions. One
Yes.
is related to you were saying that we have not to mention the law in the pleadings.
Yes.
So what kind of law we should not have to mention? You were saying you were showing a draft in which you have mentioned Partnership Act Section 69, I think.
So,
So
see, there are exceptions to the situation. I said you that law have not to be mentioned, and when law can be mentioned. So when there is a condition precedent, so if a partnership is being uh, is in picture, and there is a requirement under the Partnership Act that requires that a particular partnership has to be entered in a particular way, then you will be obviously stating that yes, under so and so section, it is a requirement. Therefore, the partnership was entered into so and so method. But if you are simply stating that section 16 of Partnership Act says so, section 17 of Partnership Act says so, that is of no meaning to your case, or for that purpose, for that matter, for the purpose of the court. You have to understand that why is the court interested, sorry, why would be the court interested in reading the law from you? It's obviously the function of the court to adjudicate based on the law. So it will be even if something on the law part is omitted from your plaint, the court may very well take care of that. So say if you have not pleaded a relief from an act which can be available to you, it is always available for the court to grant a relief based on that particular act or that particular law. So simple law should not be stated when there is a mixed question of fact and law. When your argument of fact is depending on a particular law, then the law can be stated. So these are some of the exceptions in the situations in which laws can be stated. And when you will be actually coming to the courts, you will be seeing that this is a principle which is very less followed by the parties, and parties go on stating laws in the plaints, which should not generally be the case. Is that clear?
Yes, sir. One is related to the conveyance. That conveyance is also a type of contract.
Obviously, most of the conveyance documents are one contract or the other contract. So if you arrive at a conclusion in a contract and then record it in the right form of writing. So you will first finalize, the parties will first finalize about the sale or the rent or uh, anything that is being transferred or the lease uh, or the power of attorney, and then they'll be obviously recording that in the form of a document. So it is a contract. Anything else?
Yes, sir. Clear.
Anyone else having any question? If not, then we can wind up, ma'am.
Okay, sir. Is there any concluding remark that you want to give? Then otherwise, then we will wind up.
Ma'am, I have already said whatever I wanted to say. So if there is
Okay,
no
sir.
question,
Okay, sir. Thank you so much for this enlightening lecture on basics of drafting, pleading, and conveyancing. It was
thank
a
you, ma'am.
delight hearing from you, especially the practical aspects.
There is some question, I
Miss,
believe.
yeah, Shafali Garg has raised her hand. Shafali, you can unmute yourself. Shafali Garg, you want to ask a question?
No, she has.
Ma'am, it was raised by mistake. Sorry for the inconvenience.
Okay, sorry. Okay, thank you so much, sir, for today's lecture. Hoping to hear from you frequently, and it was
Thank
genuinely a
you.
pleasure hearing from you on the topic. Thank you so
Thank
much,
you for
sir.
that. Thank you.
And thank you all the
I hope
participants for
it would
listening
have
so
been a learning
patiently.
for the students, and they'll be benefited by the further sessions because they are going to be more specialized.
Yes, sir, definitely.
Okay.
Thank you, everyone. And it's compulsory for the students to and participants to fill the feedback form. Please do the needful.
Thank you. I'm leaving the meeting.
Yes, sir. Okay, thank you so
Thank
much.
you, sir. Thank you, ma'am.
Thank you. Students, please fill the feedback form. Feedback form is open only for next 4-5 minutes. उसके बाद feedback form will be closed. आपकी attendance और feedback form दोनों भरे होंगे, then only you will be marked present for today. Students who have filled the form can leave one by one.